Hello. Hope everyone's doing well tonight. This is one that I was going to do, Free Mark Sumrell, last week, but I got to reading and I realized that I needed to do a lot more reading. So I did, and I also wanted to help out Don Morris for his daughter Ashley Morris Mullis, who is missing in Indiana. So I am finished with my research and I figured I would do this now because I don't know. I've talked to my sister, I've talked to a few different people to get outside opinions on this, and like everybody was just as outraged as I was that Mark is behind bars. So there is a petition, and that's kind of what got me looking at it. Was the petition. Someone sent me the petition, and I usually don't sign those unless I look into them and then decide, just to sign something off of change.org based on a statement on change.org. I don't recommend anybody do that. But once I looked into the petition and then fact checked it and realized that, like, it's just ridiculous. Honestly, it's just absolutely ridiculous. I think it's abuse of power, and the justice system should be, for one, it should be easier to understand, these Mississippi code and, the titles and whatnot. Like, as far as the laws go, the three strikes you're outlaw. Like, there's just a lot of different things that you'll see coming up in this live that are upsetting, that little technicalities would keep someone behind bars for 17 years. It's just a little bit ridiculous for the punishment not fitting the crime and abuse. I think it's just an abuse of the three strikes you're outlaw. Like, it's been changed. It's been since changed, and this man is still not out. And that's pretty, we'll see. Let's go ahead and get started. I'm going to share my screen and then we'll start looking at some things. So let's go ahead and start with the petition. So it kind of gives you his MDOC number. He's a black, 6-foot, medium built male, 180 pounds, and his birthday is in 1969. So remember that. His hair color is black. His complexion is medium. He was entered into the system in 2005. And he changed locations in January of 2020. And he got a life sentence without the possibility of parole in Washington County on April 26th of 2005. Mark Sumrell shoplifted a $39 jacket at a Kroger store in 2003 and was sentenced to life imprisonment without the possibility of parole in the Mississippi State Penitentiary for this crime. Sumrell, now 50 years old, has served half of his adult life toward this sentence and will never be released from prison without clemency or legislation. Kroger should release a statement saying that Sumrell has now been punished enough for the crime he committed against them. Not sure what this is. Oh, it's a different article. Yeah. Let me go back. So I figured we would just to show that he still is an inmate. Of course. this one here. This is the newest one. So he tried to, I'll go ahead and read that article first. I'm not going to read the court documents from then because they pretty much just go over the same stuff and they find a different technicality to basically deny his appeal or post-conviction relief. I don't know, like, why. No, I don't want that. Hey, Cher. Hey, Grandma Watches. How are you guys doing tonight? So, life term for theft upheld by court. The state Supreme Court has upheld the life sentence given a Washington County man on a shoplifting conviction. In 2005, Mark Dwayne Sumrell was convicted and sentenced in Washington County Circuit Court. On October 13th of 2003, a security guard at a Kroger store in Greenville allegedly saw Sumrell remove a leather jacket from a rack. The security followed Sumrell and saw him put on the jacket and noticed the price tag had been removed, according to court records. After Sumrell approached the store exit without paying for the jacket, he was detained and later charged with shoplifting. Sumrell had 2 previous shoplifting convictions and was charged with a third shoplifting offense, which is a felony. After his conviction, he was sentenced to life in prison as a habitual offender. That must be this one. So this is Mark Sumrell petitioning the court pro se for consideration appeal of order denying request for parole. On December 1st of 2022, Circuit Court Judge Carol Wright Richard denied petitioner's request that he be recommended for parole consideration pursuant to House Bills 585 and House Bill 1267. According to the Mississippi legislature, the bill were created to allow an offender whom has committed a non-violent offense of charge relief from sentence such as an habitual offender under Mississippi Code 99-19-83. Mark Dwayne Sumrell was not convicted of a federal crime for possession of cocaine in cause number 23.007 or on or about February 22nd of 1993, but rather a state crime for possession of cocaine in cause number 23.00077. The petitioner asked that this court to reconsider its decision based on fact, not assumption. Sumrell's life without parole sentence is from a 2004 third offense shoplifting cause. Therefore, Sumrell is a candidate for parole consideration and does meet the criteria for such relief. Wherefore, petitioner prays that this court find that he meets the criteria of one whom has served 25% of or more of his sentence may be paroled by parole board if the sentencing judge authorizes the offender to be eligible for parole consideration. It's always up to the judges, like they can try to hide behind the legislation, the codes, and the law. But at the end of the day, it's usually up to the judges, and it's definitely up to the governors that he could be let out. They're just being ridiculous, in my opinion. Order denying petition requesting parole consideration this matter. It's before the court of Mark Dwayne Sumrell petition requesting that he be recommended for parole consideration pursuant to Mississippi Code. The court, having considered the matter, the documents presented in the relevant case law, finds that said motion is not well taken. So basically, they didn't like the way that he wrote it because he's not a lawyer. I don't know. I mean, it's just... Ugh. On or about April 26 of 2005, petitioner Sumrell was sentenced to life imprisonment without the possibility of parole as a habitual offender for a Washington County third offense shoplifting charge. The two underlying felony convictions for the habitual offender status was a Washington County robbery conviction in gives the cause number, and a federal conviction for possession of cocaine. It just doesn't make any sense why you would get a federal conviction when it was, you'll see. The states that notwithstanding the provisions of paragraph of this subsection, any offender who has not committed a crime of violence under section blah and has served 25% or more of his sentence may be paroled by the parole board if the sentencing judge authorizes the offender to be eligible for parole consideration. In this instance, petitioner has a prior conviction for a crime of robbery, which is a crime of violence. As such, petitioner Sumrell is not a candidate for parole consideration pursuant to Mississippi Code 47-7-3. It is therefore ordered and adjudged that petitioner Sumrell petition requesting that he be recommended for parole is denied. So ordered and adjudged. Just trying to remember which... Hey, Chris. Hey, Digger Dave. I don't think... Okay, so here on December he's filed again. Like, this is his... I don't know why it won't pull up all of them. It was the other day. Like, it had all of his whole case file over here in the side. Let me try searching for it one more time. Yeah, so this is back in 2005. Mark Dwayne Sumrell was convicted of felony shoplifting and sentenced to life imprisonment as a habitual offender by the Washington County Circuit Court. We assigned the case to the Court of Appeals, which affirmed his conviction and sentence in 2006. Sumrell filed a petition for a certiorari, which this court granted. Finding no reversible error, we affirm. On October 13th of 2003, James Ross, a security guard at the Kroger grocery store in Greenville, Mississippi, saw Mark Dwayne Sumrell remove a leather jacket from a rack in Kroger. Ross followed Sumrell and saw him put on the jacket. Ross also noticed that the price tag had been removed from the jacket. Sumrell approached the store exit without paying for the jacket. Ross apprehended Sumrell and asked him to remove the jacket and go to the store's office with him. Sumrell asked if he could remove the jacket and leave, but Ross insisted that Sumrell go to the office, where Ross called police. The police arrived, questioned Sumrell, photographed the leather jacket, and arrested Sumrell for shoplifting. Sumrell had 2 prior shoplifting convictions, thus he was charged with third offense shoplifting, a felony. The trial court appointed Carol White Richard of the Washington County Public Defender's Office as a counsel for Sumrell, which is interesting because she ends up being a judge in the 2023 court documents. She's the judge that says no to his future appeals, because this was back in 2005. So the same defense attorney that was on his case then became the judge, and then she still like won't let this guy out. Um, Accepted a job with the Washington County District Attorney's Office, and Stephen Nick was appointed as Sumrell's new counsel. We find no merit nor reason for discussion of most of the issues raised on the certiorari. That's a hard word. We adopt the reasoning and analysis of the Court of Appeals on those issues. We do, however, address the following issues raised for the first time. So I'm not going to try to say it again. Number one, whether Sumrell legitimately raised the issues before the Court of Appeals, and he now argues before this court. After a careful review of the record, this court concludes that Sumrell never raised either of the issues that he now claims were not addressed by the Court of Appeals, that he was improperly sentenced under Mississippi Code on the Eighth Amendment proportionality claim. While pro se litigants are afforded some leniency, they must, quote, be held to substantially the same standards of litigation conduct as members of the bar. Appellate counsel was appointed to represent Sumrell in his appeal. Sumrell's appeal was filed on April 28th of 2005 and was assigned to the Court of Appeals in May. In August, Sumrell mailed his own letter to the clerk of the Mississippi Supreme Court and copied his attorney. The letter stated that he was attempting to perfect his own appeal, listing 3 issues that he intended to raise in his appeal. The issues Sumrell listed included an argument that he was illegally sentenced under the habitual offender statute, but he failed to mention the issue of proportionality. Sumrell did attach a list of citations to cases he deemed important, including Solemn versus Helm, which addresses proportionality. In relation to the statement of issues in an appellate brief, Mississippi Rules of Appellate Procedure, separate assignment of error shall be filed, and that issue not distinctly identified shall be argued by counsel except upon request of the court. We find a mere letter to the clerk does not sufficiently raise or preserve an issue for appeal. So you see what I'm saying here by like just it's a like procedural like things and like technicalities really. Like I get it. Like this is our country is as great as it is because of the I'm just a firm believer in our justice system, but I don't like to see it like being, it just feels like it's being used against this man. This 3 strikes you're outlaw, which, like we find out that in Mississippi is one of the like highest rates for inmates in Mississippi. And one of, not the highest, but that they're overcrowding. They've got this parole board, guy that is just deciding not to do his job is what it sounds like to me when I read the article. And they're just having a big problem with overcrowding, and they changed their 3 strikes law to basically include and there's 3 different areas where it could be used for Mark Sumrell. But basically what they're saying is you didn't ask for it the right way, under that law, not in this one, but in the other ones. Because he did try to argue that he didn't, you had to have served in, when I looked at it, his other charges, which for some reason have just totally disappeared. Maybe this is it. No, that's not it. It doesn't say anything about a federal cocaine charge. It was the amount was really low. I don't know anything about cocaine or how much is a lot, but it didn't say anything about with intent to distribute, which is usually what. So if it doesn't say that, it means it's just personal use. And it was a pretty small amount. And for one, these were in 1993. He was if he was born in 69 and 90, not very old. And then again in 2004, he gets in trouble with the shoplifting. And then because of those past felonies, he's basically just given it, he's never going to get out. Like, I don't know. I just saw his picture and it was just upsetting that, these courts, they can, like, if they wanted to, like this one, it was dismissed because he didn't get the, just here in January 2023, the appeal is dismissed for failure to pay the cost of the appeal. Just like these little things that, and then, it takes years to get a chance again to go before the appeal. So basically what he needs is he needs a judge to say that he should be given an opportunity to be eligible for parole. And he has served way more than 25% of his sentence. What he needs is a really good lawyer that can help him to file the next appeal if he hasn't run out already and then because he's trying to do it himself, I'm sure he doesn't have any money, like he keeps, messing up little things like this, just not paying for the cost. So they requested a filing fee on December 16th of 2022. And then literally like, what is that? 10 days later, they deny it because he didn't pay it on time. Shall give written notice to the party in default, apprising the party of the nature of the deficiency. If the party is default fails to correct the deficiency within 14 days after notification, the appeal shall be dismissed. The docket in this cause shows that the appellant has substantially failed to prosecute this appeal as indicated below. The docket fee should be paid to the lower court clerk if there is a pending motion to proceed on appeal. The cost of preparation of the record on appeal shall be deposited with the lower court. The designation of record should be filed with the lower court clerk. I mean, it's just like, gosh, can't you just have some common sense and be like, okay, it's not like he's murdered anyone. He hasn't raped any children. He hasn't done any, I could even understand it in like domestic battery. I think that the habitual offender law should definitely apply to domestic battery, and they should stop getting the option to use crime of passion or heat of passion as a defense. But the 3 strikes you're out. Like if you're charged with 3 batteries, that's fine. Like we're saving someone from being murdered by that person is how I look at it. But when you have someone that shoplifts and does some cocaine, like, and you just never, like, they're just in prison for the rest of their life without even a hope of getting out, something's wrong with that. Like, something's really wrong with a system that is set up to imprison someone for stealing. I mean, I get it. I'm not excusing the robbery. I'm not excusing the cocaine use or the shoplifting, but let's put it into perspective of like, this is not that deep, this is just, it's like they're just being really extra, and he's not the only one. And it's not just in the state of Mississippi. I think that where there is a will to create a law for the sake of the people, there's also a will to use that same law in a negative way. And I feel like, yes, I understand that these, as he is going through here from 2005 all the way until 2023, and he's trying his best to appeal to the court. I understand that he's not doing it right. However, a federal court did say that they did believe that he was charged, that he should be given a second chance, essentially. And the state doubled down. Like the state of Mississippi appeals court and the judge doubled down and were like, nope. And they took a ton of time. Like, how much time and money? For one, it costs about $14,000 per inmate per year. In any, pretty much in any state, that's kind of like the average cost. So times that by 17 years. You're just like, what is going on? The recidivism in Mississippi is wretched. Like it's wretched. And so I don't know what we can do. I don't know if we can make a difference, but I sure like to try. I would really like to try. I feel like I don't want to bore you guys. I love this kind of stuff, but I don't want to bore you with it. I'll add a bunch of these links and that you can do your own research. But yeah, so basically just like this is, dismissed for failure to pay the cost of the appeal. Just happened, like if I feel like if I had just seen this 6 months ago, I would have paid that. Like, I think any reasonable person would have paid that for him. And maybe he would be out. And I'm going to, like, I wanted to come on here and just kind of talk about this one. But I feel like I don't know, I'm just called to, like, not let it go, like not, I never do with the cases that I cover. When I talk to a family member, like, I still talk to them. Cher is in the chat right now. That's Ray Hanish's sister. And she's my mod, and she's awesome, and she's my friend. And we will be friends until the end, Yeah, all of the links that I saved, like, I don't know, it usually always works, but they're, like, all gone. It's so bizarre. But yeah, I'll put this in there and you can kind of look at all of the different ones where he tried to appeal. You can see, like, he submitted things several different times over the years. And my daughter is 17. I know how, like, long 17 is. I think we all kind of do. And it just, it feels like that's enough, It just feels like 17 years for shoplifting and cocaine, robbery, cocaine, and shoplifting, 3 different offenses. The ones were in 1993. So how old would he have been? I'm terrible with, like, adding. So he was born in 69. So how old would he be? How is he supposed to pay for it, right, Grandma Watches? Yeah, they let out a lot of bad people in Mississippi that don't meet the criteria for habitual offender. Like, I was just looking at a case where it's a murder case, and he was given 25 years. And so once he serves the 25 years, he will be able to be eligible for parole on murder and rape and, like, and child molesting and all these sexual violent crimes against children and hurting other humans, like where you physically put your hands and you have physically hurt someone, and they're going to have a chance for parole in the state of Mississippi, but Mark doesn't because of some law, like under a habitual offender law. Like, that's just ludicrous to me. It doesn't make any sense. He would have been 24 in 1993 if he was born in 69, Grandma Watches. Is that what you're saying? Um, 19. So he's like 54 now. He was like 37 when, 36 when on his Okay, so in his 20s, he got in some trouble. And then in his 30s, he got in some more trouble for shoplifting. And then he's been in there for 17 years paying for those three crimes, even though he'd already served his sentence on the other two charges. Um, very, those were the sentences that he served for. The other two were very normal, a normal amount of time. I think a decent amount of time that, a little over a year for each. And then all of a sudden it's just throw away the key. Like, man, I don't know. What do you guys think? Hey, Sarah Smiles, how are you? Anybody have anything that they think about this one? Yeah. You think it's crazy? Yeah. I do too. I think it's, I don't know. It just feels super wrong. But I figured what I could do is maybe try to get in contact with Mark. I don't know who runs the Facebook page, but like if surely that's something that I could do. And with COVID, it has allowed for, well, at least our state, and I know a few others that you can do like virtual visits online. So if not that, then maybe like a phone call with Mark and just kind of get his take on it and what he's done with his life in prison for 17 years. I mean, you don't, when you're in prison, I mean, there's not a lot you can like do, but there are a lot of programs, and it would be interesting to see, what programs he's done. I know a case that I covered, Robert Chambers. He murdered someone, and I covered it on another Get Vocal, but with CJ. And he's someone that I knew, and he committed murder. And I knew him when I was a little kid. I was best friends with his sister, and he killed a guy, and he definitely deserved the sentence that he got. He murdered him, just plain and simple. And he will be eligible for parole, I think, in like, it's coming up. It's within the next like 7 or 8 years. And so it's something that like you look at to see like what have they done? What have they done to better their life and make sure that they are taking the proper steps and everything. And that will be in the Indiana Parole Board's hands for Robbie. But I just feel like Mark deserves a second chance. I mean, he's an older man now. He's 54. Like, enough's enough. Like, let's let him go. Let's let him have a chance. He's not killed anyone. He's not raped anyone. He's not molested anyone. He hasn't battered a girlfriend. He's not done anything violent to say, oh, he's going to do that again. If he shoplifts again, then fine, I guess, throw away the key. But I just feel like there's something that we can do to shift things. And I know we're super small, but maybe, I think crowdsourcing is a big deal. And when we can all work together, I always say that, but when we can work together, we can make a difference. And I would like to make a difference for Mark. I think that he deserves it. And that's really about all I have on Mark. Hey, here's your cold cases and chaotic beauty and crime, which I think I'm going to be live with you later. Is that correct? But yeah, I appreciate everybody that was here, and I appreciate that you guys were so respectful and you stayed on, point with listening to Mark's story. I know there's other things going on, like, but I was going to say something in the beginning, like telling the mods to like not allow any of that. And I was like, my channel just doesn't really do that. Like, I don't have a lot of trolling and in the chats anyway. Like, so I didn't, and obviously everything went fine, and I didn't need to make any kind of statements about what to talk about and what not to talk about. But I think what I'm going to do is end this live, and then in like a half an hour or so, I'm going to come back on, and I'm going to address some of the elephant in the room and address like what's been going on with that, and what there's just some dumb stuff, but I don't want to do that on this stream. So I hope that you guys will all be back. Like I said, probably like a half an hour or so. I've got to talk to Chaotic, but I assume that if we did go live, it's going to be like in the middle of my night, but for her, it'll be like her like dinner time. But, yeah, I've got some things to say for sure. So join me in a little bit for what I have to say. So, all right, guys, thank you for being here. I really appreciate it. And if you would like to sign the petition, I would really, really appreciate it. It is in the description. And join the Facebook page, show them some love, let them know that, like, we care. And thanks. I will see you guys all in a little bit.